Brian, you may begin.
Thank you, sir. On behalf of the U.S. Commercial Service, in coordination with the District Export Councils of New Jersey, San Diego, and Connecticut, we welcome all of you to the 7th webinar of our 10-part export compliance series during World Trade Month. Today's webinar is titled Site Visits, Enforcement Actions, and Voluntary Disclosures. My name is Brian Beams, your host of today's session. The producer of this series is Mr. Tony Sargis. Before we get going, just a recap on what has been accomplished and where we're headed. Next week, some really good ones, folks. Export controls at trade shows, and of course, very important, understanding the Foreign Corrupt Practices Act. And then finally, we'll wrap up the week after that with bringing our professionals back on, our subject matter experts for this 10-part compliance series to allow the audience to ask a question. This is a really good time, a wrap-up session as we feel, where you, the audience, can get more value add and kind of carry out your exporting ways. Before we get going, just want to mention everyone is currently on listen-only mode. This session will be recorded. If you object, please disconnect at this time. Participants, you can write in a question at any time into the Q&A feature during this presentation. We will have a Q&A component at the end of this session. So please, again, feel welcome to write in a question at any time. Next week, we will send out, not even next week, Monday, I even know the day, Monday, next Monday, we will send out the recordings of both sessions and the resource materials as well. And then at the end, or I should say the beginning of June, we will send out all the recordings of all the sessions with all the presentations and the resource materials. Lastly, the views and opinions expressed in this presentation may not reflect the official policy or position of the U.S. government. I'll now like to welcome in Alfredo Fernandez, partner at Shipman and Goodwin. Sir, Alfredo, how are you, sir?
I'm doing well. Thank you, Brian, and appreciate the introduction. And thank you for giving me the controls of the WebEx here. Appreciate it. So our topic today is focused on enforcement, or when things have potentially fallen out of compliance. And looking at the list on a few slides back, it looks like the last session was about developing an export compliance program, which wasn't when I presented, but a very important topic. And I hope a lot of the attendees today had a chance to view that. Today's session will be a little bit more of what happens if you do have a compliance program, some kind of deviation or a foreseeable or unforeseeable occurrence happens where there's the potential for a violation or a non-compliance of the law and the consequences that would come with that. So we'll jump right into it. But by way of background, a lot of my work is on the compliance side of things, making sure the operations of a business are in compliance with the laws to prevent today's topic, enforcement, violations, non-compliances, etc. But we have clients that find themselves in those situations, and even the most well-intentioned clients that are trying to do the right thing find themselves in some hot water once in a while. So today we'll be looking at the multi-agency enforcement framework. We're not just dealing with one agency, we're dealing with a well-connected web of federal enforcement type entities, and we'll show some of that in a minute. We'll go through a couple of the recommended steps for how to handle a site visit should one ever happen for your business or enterprise, and how to do your own internal investigations before or after any kind of government visit. We'll talk about different types of disclosures with a focus on voluntary disclosures that are more common, but there are a couple instances where they could be mandatory or directed. And then we'll go through some recent guidance that's come out from various corners of the government, from different agencies on enforcement priorities, agency positions, and guidance documents, FAQs, things like that, just in the last year or so that do change the game, change the calculus quite a bit when it comes to evaluating how you're going to go about an enforcement case or a voluntary disclosure, et cetera. And we'll we'll end with a couple case studies of some pretty splashy enforcement cases just in the last few weeks. Actually, I think all less than 1 month ago. It's a pretty hot time of seeing a lot of enforcement action. So we'll get into that agenda. So by way of enforcement overview, and we'll start broad and drill down a little bit deeper as we go here. The three main agencies that attendees of this seminar have gotten a little explanation of all these things on separate sessions. The EAR, just to catch up those that may not have caught all of them, deals primarily with commercial goods, a couple military goods that have moved over from the ITAR and those that are considered dual use or equal applicability to commercial or defense type applications. The largest number of exports fall into the EAR. The ITAR is the defense-focused export control regime managed under the Department of State and their Director of Defense Trade Controls. And then connected but separately is the Office of Foreign Asset Controls, which manages the economic sanctions put out by the U.S. government with a combination of executive orders and regulations and lists and things like that. And they tie into export controls, but they're not always purely export controls per se. All those three agencies are probably the most common ones in terms of the laws and regulations that trap potential enforcement, but by no means are they the exclusive ones. But when you're thinking export controls and economic sanctions, those are the three. We won't go through every little word here on this slide. We were just pulling together here various types of agencies that have been involved in some of our matters with either export, import, or sanctions type compliance, FCPA, anti-bribery, anti-boycott. So there's lots of ways to get in trouble, so to speak, with violations of the law. And it's not just one agency you have to worry about. You kind of have to keep a broad perspective as to how we've seen actual companies deal with the unfortunate occurrence of a violation there. So we'll get into one of our topics for today, our subtopics, which is site visits. And hopefully none of you have had to deal with it, and hopefully none of you have to. It can be a little anxiety inducing if you're in charge for your company, because you really never know what the inspection will visit. We'll start with a couple established programs and then get into kind of a more generic site visit set of slides here as to how we recommend we go about those. Generally speaking, the agencies have authority to visit facilities, ask questions, request documents, take a look around, and we'll get into that in just a little bit. The BIS, the Bureau of Industry and Security, the one that administers the EAR, Export Administration Regulations, has a visits program, and that's conducted primarily by their OEE, their Office of Export Enforcement within BIS. One of these programs is called the End Use Check Program. And OEE, in this case, will actually go to a foreign location, your buyers or a potential distributor or something like that, and do a little bit of real kicking the tires to make sure that party overseas is the real deal, they're legitimate, they're doing what they say they do. And the foreign entities have to cooperate or risk being added to the naughty list, so to speak. BIS has recently refreshed their policy on this, that if they are going out for an end-use check and they're not getting the cooperation, BIS will add them to the unverified list. And that's a searchable list, that's a public list, and it essentially gives potential exporters a heads up that there's something we can't verify out there because they're not giving us the information. After 60 days, based on the new policy position, if they still haven't gotten information from this particular foreign user, they'll move that company to what's called the entity list, which is a little more severe in terms of potential restrictions for exporting, and there may come, addition to the entity list, may come with some specific restrictions or extra hoops to jump through before an export to that entity is approved. So the foreign recipients or end users are incentivized to cooperate so that they don't get essentially barred from U.S. exports this way. But again, that is not necessarily a site visit for you, but it is a type of site visit that BIS does do, and it does emphasize with the COVID. Obviously, things got a little bit adjusted there, but things are apparently coming back in more of their prior full swing. Similarly, DDTC, the Director of Defense Trade Controls, has what's called a company visit program, and this is focused on ITAR registered companies. And this is a little bit more for them, DDTC, the agency, to see the businesses in real time, in the real world. They're doing this to understand how are people's compliance programs getting worked into the actual business processes. Are our regulations working? Are people understanding them? Are they able to take what we have in the regs and apply them to their real operations and see best practices? And if one company is doing something particularly well, they may work that into some other guidance or something like that. These visits aren't considered an audit or an inspection, and they do pick from the list of registered entities or ITAR registered entities. So they can, for example, if they want to focus on somebody exporting titanium parts for the aerospace industry, over $9 million of exports, they can filter to a certain extent which businesses might meet that mark if they want to go for a particularly targeted type of visit out there into the field. And now we'll transition a little bit more to at home, your own facility for an actual inspection and what to expect. They can cover all areas of operations. That can include compliance with licenses that you have in place. So you've had to go get an EAR license or an ITAR license. There's some conditions baked in there, or you have an agreement like a technical assistance agreement. There's lots of requirements in there that can be covered. They can be looking at that. They could be looking at how your floor is laid out, how you control foreign or non-U.S. persons in your facility with respect to potential ITAR controlled access, et cetera. And we recommend a standardized process basically for any agency, because a lot of these things are pretty, can happen to regardless of which agency actually shows up to your door. We break it down into a 5-step or a 5-phase visit process, and we won't linger too long on any of these in the interest of time, but we'll flip through some of our recommendations for, if you find yourself in a site visit type of situation. One of the most important parts is the pre-inspection. This happens, can happen today after this webinar if you wanted to. It's basically the get ready phase. You do want to conduct routine evaluations of your own house on your own terms while it's quiet, while there's no pressure or no government agent lurking at the frame of your door. And you could go ahead and check your own compliance with your existing licenses or agreements if you have them. If there are some reporting and record keeping obligations that go in with any of those licenses, have you given the DDTC an annual report of this or this that's required under your agreement? And if you do find some non-compliances, you can address those so that your ducks are in a row before a visit. One of the most important parts of the pre-visit or pre-inspection phase is picking somebody at your company that's going to be the designated representative for a government inspection, so that they know the process, they kind of know the drill, and it's clear once that person happens, or when an agent shows up, this person gets the first call and will be the face of the company for whether it's an hour visit or a full day visit. It's clear who's going to be handling that as well. And then you can do some written procedures. You don't have to, but sometimes having some, like a standard operating procedure in writing is helpful for some companies. At the initial contact, you want to check the credentials, make sure you get the name, business card, contact information of the agent in case there's some follow-up. And if you want to just make sure it's the real deal, check the badge and the real face, make sure everything looks like a match. And the important part here is the more you can predetermine the scope and define what the scope of this visit will be, the less likely you are to deal with the risks of potential scope creep if you just walk into the middle of the floor without really understanding what's going to happen. So we like to recommend to our clients understand how long the inspection will take. Is it supposed to be a quick thing? Is it going to be an all-day thing? Do I need to go cancel my meetings? And understand the goals of why are you here as an agent of the government. Understand what areas are you looking to inspect, or what types of documents will you be requesting to see. Understand if they're going to need any types of samples or photographs, and depending on your business, that may be applicable, that may be not applicable at all. And understand any special constraints, like, for example, if PPE is required for parts of your facility that you would have to go to, or if there's special OSHA safety type training, like there's a fall risk or something like that, that may affect the boundaries of the inspection, things like that. Not super common, but sometimes they do come up. And if you have legal counsel, you can send them a text or an email to say, hey, I have an agent here. Can just a heads up, or can you come by if you're available? That's up to you. If you want counsel there, you're generally allowed to have counsel if you want. During the inspection, the designated representative should go around, accompany the agent the whole time, take notes as to what's going on, what they're looking at, the topics of the conversation. You can hold the conversation naturally, but leave yourself enough notes so you can kind of recreate the discussion, provide access, if you need to scan in to certain areas. If they are asking for documents that you believe are attorney-client privileged or something protected, for example, or maybe top secret, or depending on the level of your programs, feel free to say, I need to check if this is allowed to be shared, even with the government inspector. You want to keep records, or get a copy of everything you actually provide. If the inspector needs to take any documents back that day, it's appropriate to ask to make a copy of everything that's taken, just so it's clear which documents were taken by the inspector or not. And if certain things are not available, you're allowed to say, we'll look for these and get them to you offline separately, and make sure you have email or other kind of contact information that you need. And to the extent pictures are taken or anything like that, you're allowed to take pictures at the same time, or make a note in your notebook to say, he took a picture of the paint booth with these 3 parts in there, and then you can go back after the walkthrough and get the same picture, just to capture what would be in the inspector's file. After that inspection's done, we recommend a request of the inspection report, and this is while the inspector is still here, kind of a debrief before you get going type of discussion. Sometimes the inspection report happens right there in the moment. They're going through a form, they're checking boxes, they're filling in some comments, and they could give you the inspection report right there. Sometimes they need some time to type it up or revise it separately, and they can guarantee you'll get a copy of that later. You want to discuss the findings right there, see what they have to say, what's their immediate impression, and if there are some violations that have been confirmed or suspected, understand how the inspector is viewing those, and if there's something you need to do by way of immediate action. And then after this inspection, you want to brief your company leadership, let them know what it's about. Take your notes. We recommend just putting them into a file memo, so that kind of captures your present sense impressions of the visit. If there was any follow-up you agreed to, you want to make sure you go ahead and follow through with that in a timely way. And if some violations were identified and discussed, you want to make sure the company goes ahead and takes care of that in a timely way as well. So those are, I hope that didn't sound too scary. These things happen all the time. But these are just some things to think about early, so that when a visit, whether planned or unplanned, happens, your company has a plan, your company has a go-to point of contact, and they know what to do. So that's the takeaway there. One of the ways to get comfortable that you are ready for a site visit is to do an internal audit or an internal assessment. This prepares the team from the reception desk to potential other folks that would be involved, but most importantly, the designated representative could work with like a third party that you hire to go through and do an internal assessment of what a typical site audit might look like from an international trade compliance perspective. You could do that with internal resources if you have it, or an external resource. It could be counsel, it could be non-counsel. Doing it through counsel may offer the advantage of the attorney-client privilege, so that the findings are privileged until potential non-compliance is discovered in this process are fixed as well. And overall, the thinking is, if you find some of these issues ahead of time on your own accord and take care of them, you won't necessarily have an inspection violation type problem. So we'll pivot a little bit here while I take a sip. As to a different type of enforcement issue, you've shipped something and it's not going where you want, or you're trying to import something from a supplier and it is not coming through. It gets stuck at customs, or there's another block in the shipment process here. Customs and OEE have the authority to inspect shipping documents and search containers. That you're crossing a national boundary, whether it's a land boundary, you're going by port, by airplane, they're allowed to look. They don't need a warrant or probable cause to do so. You're by subjecting yourself to international commerce, that's a given that they have the right to, but not obligation to check every single shipping container. One of the options that could happen with an issue is forfeiture, wherein that property becomes the property of the federal government. That's pretty rare, and more for extreme cases. Seizure, a little less rare, where they will seize a container or a shipping container until some kind of money is paid, whether that's a tax that has to be paid, or tariff on the way in, or some kind of bond payment that, or the paperwork's just not lining up. Until that gets sorted out, that may be held. On the other side, if you're exporting, but the license information isn't there, and it's an export that would have required an export license, whether ITAR or EAR, and the documentation or the information, the license number isn't included, it can be seized on the way out or detained if they need to. We had, just by way of example, a client get a call from an agent from Homeland Security Investigations, from the Department of Homeland Security, and asked for a bunch of information about a shipment that was trying to go out through the West Coast last week. And client called us and said, is this real? And if it's real, what do we do? And it turns out in this case, the U.S. exporter was not the target of anything. They had been, agent couldn't tell me all the details, but the gist was that the agent was pulling together a paper trail because the recipient of this particular good, or package of goods, was on their radar for potentially diverting things to Russia and Belarus, and essentially lying to U.S. companies as to where their products would be going. So they asked our client to cooperate and share some documents so they can better understand how they're going about procuring U.S. goods, export controlled goods, and getting them into locations that are prohibited by U.S. law. So an interesting one. Thankfully, here our client's not in the crosshairs, but it is there was a seizure situation that got cleared up, and et cetera. But these things do happen, and agents are looking at what's coming out and what's coming in. I'll breeze over this for a little bit because we covered a lot of that. Now we're getting into some potential different types of investigations. We'll start with the most serious and kind of water it down from there. Criminal investigations can happen in this international trade space, and these are particularly reserved for individuals or entities that are knowingly and willfully violating the laws, or evading the laws, or playing some kind of game to get around the laws. where it's not, wasn't an accident. These violations of the law were purposeful. The agencies have different techniques to get into or start their criminal investigations and carry them on. Different types of warrants, sting operations, subpoenas for documents, or they can essentially say you have to be in court, or get us these documents by this day, or they can do some undercover type visits. In certain cases, they've asked a client of ours to play along and pretend to be a buyer or a seller, just so the target of the investigation could get caught in the act, and you get some cooperation credit there and some goodwill from the agent. So lots of high stakes things are happening, but it is, like I said, reserved for those purposeful bad actors, not necessarily a company trying to do the right thing that messed up this or that inadvertently. Now, in an enforcement case, it could go several ways. And this is, applies to not just criminal cases, but any kind of enforcement case. If it turns out there's nothing there, they could just close it internally pretty quick. That's a great result. Or they could issue a no action letter or a cautionary letter if you are playing close to smoke but didn't necessarily find any fire. They'll give you a cautionary letter for the record. They could find a violation too with a letter, but indicate that there's zero penalty, or depending on the facts, can issue a civil monetary penalty. And I didn't include in the slides today the per violation penalty maximums for the various agencies, because sanctions have their thing, the ITAR has its things, the EAR has its things. Needless to say, a lot of these penalties are based on a per violation basis, and with repeat conduct, those penalties can really snowball into some very, very large numbers that we'll see at the end of the presentation, with some eyebrow-raising penalty amounts. Another option is, if for bigger cases where it's a pretty involved set of facts with a big settlement involved, there could be a number of agreements, including some deferred prosecution, where part of the penalty could be held in abeyance, and as long as the company does requirements 1, 2, and 3 over the next X years, the government will go ahead and waive the penalty and write off any potential further prosecution, with the goal of just getting that company into order. And that's usually reserved for bigger companies that have some good internal wherewithal to staff what needs to be done. If the facts require it, a criminal referral could be an outcome, and that would go to DOJ or a different type of prosecutorial body to look at criminal elements. And to the extent you have licenses approved or pending, an enforcement case could potentially hurt what you're already using or trying to get by way of licensing too. If it's particularly heinous, you can lose all your export privileges, and any licenses you do have go out the window or are null and void there too. So obviously you want to, compliance is not just, your compliance can affect other parts of your business as well. Different customers, maybe different departments that are not necessarily working together, different sales teams. The error of one on a compliance issue could potentially impact another account and things like that. We'll briefly step through here. I picked the OFAC enforcement guidelines, and for those who attended the OFAC session, may have seen this before, but just as a representative set of guidelines for what the agencies are looking at in the enforcement capacity, and we'll breeze through this here too. In an enforcement case, OFAC is looking at the conduct. Was it willful and reckless, as I mentioned? How much knowledge of the transaction did the decision makers really have? Was it actually harmful to the program objectives? Is going easy on this company going to kind of force us to go easy on the next time this happens? Is going hard on this company going to be a good enough deterrent for other companies to avoid these types of issues? And obviously they look at some fact-specific things about your company, your existence of a compliance program, your use of a compliance program, How'd you handle the response when you found out about it? And how have you been cooperating with OFAC? All those are multi-factor considerations in an enforcement situation, and you want to be getting as many points on each of those as you can. So one of the, how should I phrase this? One of the techniques to understand what an investigation might look like, as we mentioned, was the internal audit. That was more of a proactive one without a violation necessarily identified to initiate that action or activity. And we highly recommend those to look inward and look in the mirror and see how you're doing. There are situations where it has to be reactive, right? No amount of planning could have dealt with this thing that popped up. You've identified an issue. Somebody brought it to you. Hey, I think we accidentally shipped this box to the wrong company, or we sent an email file or opened up a share file link to whatever, and it was a violation. The wrong stuff went to the wrong people, and we're in trouble. So in that kind of scenario, you do want to undertake an internal investigation, to make sure you have all the right facts. Sometimes the people closest to the facts are the ones that may have caused the issue and may not be necessarily the neutral party in determining the full facts. So having a neutral, impartial internal investigator help figure out the real facts is important. And you want to figure out, we don't have to look at everything and every potential problem. Let's look at our main problem here, and undertake this investigation promptly, not too fast, right? You don't want to cut corners. You don't want to miss something relevant, but you want to get started pretty quickly after discovering that, and make sure your scope is okay, so it doesn't become too big of a thing where you're looking at that too much and missing the forest for the trees, so to speak. There could be an obligation to preserve documents. That's a good best practice anyway, just to make sure things don't get deleted by a nervous employee or something. And we, in certain cases, help clients issue what's called a legal hold or litigation hold if there's a risk of a litigation or some kind of enforcement action because of this. And that's important because the lack of those documents could be a presumed sign of spoliation, or that you purposely spoiled or got rid of those documents. So to take that off the table, we just recommend a preservation of relevant documents there. You don't want to coach witnesses into what they're saying or tamper with that, because that starts looking worse. Sometimes the cover-up is worse than the crime, as they say. And you can use internal resources by all means. If you have it, if you don't really have somebody skilled in this area, you could bring in outside help, of course. If there's a lawyer involved, you want to use the attorney-client privilege strategically. And there could be some local issues. For example, if you're dealing with a subsidiary or a parent or an affiliate company in a different country, what you're used to on U.S. law may not necessarily apply in a foreign jurisdiction. So we have seen some issues where the data privacy laws don't exactly match up with U.S. standards, and other kind of employment rights type of thing. They're just different in different jurisdictions. So having an eye for those types of issues if you're dealing with an international type of issue, and again, counsel can be tapped at any time. Now there are a few. So transitioning here, if you've done an investigation, you think you've discovered a violation, you did internally your investigation, and you did confirm it. All right, this happened. It's unfortunate, but we have a violation here. You're going to be faced most likely with the question, do I have to disclose this to the government? They might not ever know. If we just stay quiet and move on, fix the problem, of course, but carry on business. And that's generally a decision point that's there for you. There are, however, and we'll get into pros and cons of that approach. However, there are a couple situations where the law says if you're aware of this violation, you have an affirmative obligation to disclose that. On the ITAR side, there's a section called section number 126.1, where there's a list of specific countries. It's not a long list, but if there is a specific type of export to one of those countries, you have to disclose if it's unauthorized. For example, arms exports to China would be included in 126.1. And even if you find it voluntarily, the law says you need to disclose that to the government. There's no judgment call. That's what the law or the regs say. Similarly, on the EAR, they have some anti-boycott language where if a violation is discovered there's an affirmative obligation to disclose. Or if a government agency says, we've identified this violation, you need to give us a disclosure to summarize all the facts around this thing. The optionality there is gone. That's a directed disclosure, and it will be mandatory for you to prepare. On the other side, much more common, is the approach with voluntary disclosures. And voluntary means voluntary most of the time. And we'll get into some later on how voluntary actually is based on very recent guidance coming out of BIS in April of 2023. But voluntary disclosures can be a very useful tool, and we've submitted dozens of, if not more, of voluntary disclosures. They can be disclosed for confirmed violations or even potential violations where you can't really confirm one way or the other whether the violation occurred. Say, for example, your internal IT controls were out of whack for a few weeks and nobody really noticed until the security gap was identified and fixed, and there's no tracking, but a certain number of foreign national employees could have easily, popped in there and seen what would have been export controlled technical data, but there's no way of confirming yes or no, right? You could go in preemptively and say, hey, we discovered this. We're not really sure if it was an actual violation, but it was certainly a potential violation scenario, which usually, in most cases, the government will let it pass. There are benefits of disclosure, as I mentioned. It does count as a very significant mitigating factor in terms of penalty calculations. It's no guarantee that you get to leave with $0 in penalties, but a lot of the time, if it's a relatively minor violation, the fact that you voluntarily disclose, you cooperate with the agency, you fix the problem, often, and in our experience, results in a full mitigation down to a $0 penalty. It will be a confirmed violation, but it's $0 penalty, and you get to move on without too much of a financial pain, other than going through the process of disclosing and fixing the issues. In recent DOJ guidance, I'll note here, that's Department of Justice, and they have a national security division, a criminal division. The guidance from the Deputy Attorney General is for prosecutors to not necessarily go after guilty pleas, and this is in the criminal lane. If a company has voluntarily self-disclosed, they've cooperated, and they've remediated their misconduct. So that's a pretty powerful benefit of the voluntary disclosures in terms of potential criminal results there. In the voluntary disclosure, if you do end up deciding, I'm just going to do this, there are some elements that the agencies expect you to provide so that they can understand what happened here that caused this disclosure. They want a description of the violation, whether it was a physical shipment, whether it was a visitor to your site, whether it was a email or some kind of IT-related control. Just tell us what happened, or something got diverted in shipments because of a mistake on paperwork or whatever. Give them the facts and let them know, like, would this have been an easy license request if we had gone ahead and asked for it, so that it's kind of no harm, no foul, in the sense that you would have blessed this ahead of time. We got out of order and out of sorts there with our procedures. They do want to understand a little bit of the root cause here. And that takes some work sometimes. Why did this happen? And some of you have used tools like the 5 whys or things like that to get to root cause analysis, outcomes. So those types of things are useful in determining why this violation occurred, useful both for the government and useful for you too as the U.S. exporter to understand why, and you want to address the why so that why doesn't happen again. The degree of cooperation with the investigation, if you've been cooperating with questions, you want to bake that into your disclosure too. That we've been playing along nicely as a good corporate citizen here, and some explanations as to what you're doing to prevent this type of shortfall from happening again. Generally, they do expect a pretty fast disclosure timeline. We generally, if we think we're going to have to go in, but we know it's going to take a while to get all the facts, we'll submit an initial disclosure that basically says we've identified an issue with A, B, and C. We're going to collect the facts in more detail, and we'll get back to you within X days. It could be 60, 90, 120. There are some guidelines in the regs. I'm blanking on the exact day, but you can essentially draw the line in the sand so that you have disclosed voluntarily, but you have more time to go figure out the facts. Now, the next few slides will be some updates just in the past year that do affect the strategy for voluntary disclosures. BIS specifically has instituted what they call the dual track processing of voluntary disclosures. Some of the more minor or technical violations will get a warning letter or no action letter pretty quickly. 60 days, you get your letter that says, okay, sounds like or looks like or confirmed to be a violation. No action, no penalty. Keep working on your export compliance. For more serious violations that aren't those, they'll staff a team on it and get into more detailed follow-up and figure it out that way. So that's relatively new. Thankfully, I haven't had to go with the more serious side on behalf of a client yet. All of our other ones have gone in the fast track of the dual track there. So I'm still curious to see how the more serious ones will be treated, but it is pretty useful because it does take away a lot of staff time, or this process more efficiently uses staff time to let the little things go, focus on the bigger issues, and use staff resources more efficiently. Just last month, this has been getting a lot of buzz in my circles anyway. There's a BIS policy memo that was released, and basically forever, the fact that you voluntarily disclosed a violation resulted in some kind of mitigating factor benefit for the discloser, wherein, as I mentioned, sometimes it's so helpful that your penalty becomes zero and you get your letter and you keep on going through your business. Up until recently, the lack of a voluntary disclosure, except for those mandatory exceptions I mentioned, the lack of a voluntary disclosure had not been, at least by public position, an aggravating factor for potential penalty negotiations. So what's that mean? The memo says if you disclose your violation, we'll give you the mitigating penalty. But if we're looking into you and we found out that you deliberately identified a violation and deliberately chose not to disclose that to us, we're going to view that as a aggravating factor or some kind of non-cooperation factor to up what would have been a base penalty is now going to be more expensive for you. And this is a pretty significant shift in terms of BIS policy position. So when you are viewing the potential path in front of you, we've discovered a violation with our own internal assessment. we could do a voluntary disclosure. We could keep it to ourselves, fix the issue, but stay quiet about it. Now has to consider the fact that if you do get investigated for something else, and or for whatever reason you're under the scrutiny of BIS, and the knowledge that you didn't disclose that identified violation years ago, could be a potential issue in terms of dollars. So that it doesn't mean you absolutely have to disclose with this policy memo, but it does change the calculus a little bit here, for that position. And before I forget, that's the most talked about piece of that memo. Another piece of it that I don't want to forget here too is that BIS will also hand out mitigating factor considerations if you tip them of a non-compliance for a third party, a competitor or somebody you're doing business with. Say a reseller is doing something you don't like, you can send in a tip. Or one of your suppliers is doing something, like I said, or you catch wind that your supplier's doing something sketchy. You're playing by the book. I know my competitor can't offer those prices without doing something here, and here's where I think they're doing something wrong. You can bring that information to the BIS, and if they investigate it and find an issue with it, you would have essentially a little bit of credit in the BIS bank for a potential future penalty issue, if you find yourself there where you've gotten some mitigating factor by helping them understand where some other non-compliances are. So it's puts a little bit of finger pointing out into the regulated community, but a factor to consider too. So if you do know that a competitor is probably playing fast and loose and taking a competitive advantage away from you that are playing by the book, you do have that option, and it could credit you in a positive way. And then lastly, in terms of recent updates here too on enforcement, this is through the Deputy Attorney General, Lisa Monaco, building on a prior memo she had published a year prior in 2021. And it's a letter to the prosecutor community and the federal prosecutors, to establish a little more consistency with the U.S. attorneys and things like that, where a little bit more focused on the criminal side of things, but not exclusively. And sometimes these AG memos kind of get absorbed by unofficially by other agencies in terms of the philosophies. But the emphasis here was that companies need to be timely if they are disclosing. If they want to get credit for disclosing, it's got to be fast. They can't drag their feet for 6 months to do the full investigation, then tell us. They do expect to see timely disclosure and document production. They do carve out some timelines in terms of prior noncompliances. If a company had a violation more than 5 years ago, a civil violation more than 5 years ago, or a criminal violation more than 10 years ago, they recognize that companies change a lot in that time period, and those are given less weight from a kind of a penalty negotiation, an aggravating factor type issue, which is generally good, right? So if enough time passes, your prior noncompliances become less and less important. The memo also explains a little bit more as to how compliance monitors could be or should be used. And a compliance monitor is a third party person that comes in and essentially is a pair of eyes for the government as to a company's compliance. This is generally reserved for bigger companies. So I won't linger too much here either. And then interestingly here too, they do provide some guidance as to how a compliance program is structured, and they look at whether the companies are allowed to claw back compensation for executives that were engaged in criminal offenses, and or are they rewarding good compliance behavior as part of their compliance program? So those factors will be baked into the overall corporate criminal evaluation type of analysis. Again, most of the companies here will never necessarily need to go through a DOJ type of criminal investigation, but it is a relevant document for purposes of the compliance community. And then as we turn to bring it home here with the last few examples. Both of these are from the last month, April of 2023. We picked a couple big money settlement decisions that were just really, really big. And as an example of the seriousness of compliance and enforcement, efforts and budgets and if the cost of compliance strikes you as expensive, you should see the cost of non-compliance. And these are a couple examples of the cost of non-compliance. Here, this was an OFAC violation where a company, British American Tobacco, had been selling tobacco cigarette products to North Korea for years using various shells in Southeast Asia and distribution kind of diversion points there that were just hard to track, and purposely essentially avoiding these sanctions, the comprehensive sanctions on North Korea. And they got caught, right? And it was so many transactions over the years that the penalty is just staggering at 500 million for pushing cigarettes. But anyway, it was a big one, and we wanted to bring that up as an interesting case. And here that did I mention $508 million there. So here another really big one, $300 million. This one was through the Department of Commerce against a company called Seagate Technology. Here working with a circuit board and electronic components, going to Huawei, who has a special restriction from the BIS and it's a huge Chinese technology company, but they have some special export restrictions imposed on that years ago. But this case exposed a lot of sales to Huawei, and through a series of purposeful schemes to get away from the regular export controls, and they got dinged pretty darn hard. I think this was one of Department of Commerce's biggest penalty dollars by way of enforcement ever. So big ones. Most companies are not going to have to deal with the multi-million-dollar penalties. They are, we see some at 500,000, 1 or 2 or 3 million. I saw a couple more this morning in that range. But as we said, if you're here doing a training, it's because you are trying to do the right thing. Those kind of companies are generally going to be able to identify perhaps a minor technical issue and be able to voluntarily disclose that for 0 or a very low penalty amount, showing good faith and the ability to cooperate and fix the issues and try to improve going forward. So I don't include these last two whoppers to send anybody into a tizzy or make you lose sleep, but the cost of getting this wrong in a big way is very significant, and hence the emphasis on the compliance side before you have to call the lawyer for the enforcement parts. So that's, I think, basically the end of my my material. My contact information is here, and Brian or Tony, if there's any questions, I'm happy to field them.
Alfredo, thank you so much for your offering your time and explaining some serious situations. I'm amazed on how much those fines were, those penalties. But folks, from Alfredo Fernandez, partner at Shipman and Goodwin, take him on his word. Take him on his suggestions. He's a very good resource.